May I please?
Yes.
Mention this.
May it please your lordship.
CRP,
Yes, madam.
CRP 50.25, this matter may kindly be listed on Monday, what happened, this
CRP?
CRP,
No, I think mention has to be made before the senior bench.
It's civil division.
Civil division, that is why. Mention senior bench, except for bail. Okay. Yes. Yes.
May it please your lordship.
Yes, sir.
Lordship, with the consent of the other side, I beg to mention item number 11, lordship. In this matter, lordship, an affidavit has been filed today on behalf of the government of Assam. So that is not on record. That has not come on record as yet. May
Okay,
I pray for posting the matter after 2 weeks, lordships?
Well, I appear for the petitioner here, my
You are
lord.
for the petitioner.
And my learned friend appears.
Well, I'm appealing for the respondent of 4, madam. That affidavit, I suppose, it has been filed by the deputy commissioner, madam.
You have received. You
Yes,
go?
I'm
The
not
affidavit has
respondent
been filed by the chief secretary, lordship, state of
There are
Assam,
two,
lordship.
yes, but there are two affidavits filed by the chief secretary. One was already filed. Today they have filed one more. I'm appealing for the respondent number 4, madam.
And she is appearing on behalf of?
See, both are
Respondent
same, madam.
number
She has
4,
filed
lord.
another affidavit, madam. She has filed one more affidavit. She is with me, madam. I'm also appealing for her.
Okay. So,
My lord, could it be on 4th of August, my lord?
okay, you have received the affidavit? No.
I have received. my lord.
Okay. Mr. P.D. Nair, Learning Counsel for the petitioner. Mr.
PN Goswami, madam.
Goswami, Learning appear.
Additional AG Assam, madam.
Additional?
Advocate General Assam, madam.
Okay, additional advocate General Assam appear on behalf of the respondent number
4, madam.
4. And Sami said he has filed affidavit
Yes, madam.
on behalf of respondent number 4.
4.
Okay. Mr. Learning Counsel for the petitioner. Just a minute. Then what? You have this. Who else has filed affidavit apart from 4?
My lord, the state of Arunachal Pradesh has also filed.
Okay.
For us. My lord,
And who represent?
my lord, all the affidavits may be directed to be brought on record. The affidavits filed may be directed to be brought
Okay.
on record.
I'm for the state law. sir.
And Ms.
1.3.
Al-Haqib
1, 2,
for
and
the
3.
state of Arunachal Pradesh. Respondent number?
Should be 1, 2, and 3, madam.
Okay. For respondent
No,
number?
no,
Sir,
no.
only one, madam.
Only one lordship.
Only one.
Okay, respondent number 1. And who else?
2 and 3.
Okay. Who else has filed affidavit apart from 4?
Well, that 4 affidavit will cover by the rest of the affidavits will stand, madam. because
Okay.
The others are state of Assam, madam. Affidavit has been filed by the chief secretary, madam. He is the respondent number 4.
Lorships.
Okay.
And the 5, 6, 7, 8, these are officials of the government of
So
Assam.
it has not come on record.
It has not come
Affidavit.
on record.
Okay.
It has been filed
Affidavit.
today.
Okay. However, the affidavit so filed by the respondent has not on record. Is requested by the Learning Counsel for the party. List this matter again on. List this matter again on
My lord, 4th of August, my lord.
4th of August.
Lorships.
4th August.
Kumbh.
Okay.
My lord, there is an interim order operating. my lord.
The interim order passed earlier to continue till the next date. Okay.
My lord.
Till then. Huh?
Deeply obliged.
Obliged to lorships.
Okay.
May I please, my lord? My lord, I beg to mention item number 5.
Item 5.
Yes, kindly Meta may adjourn for that. The conducting council is out of station. D. Kamduk.
Okay.
For the appellant, ma'am.
You are for the petitioner.
Petitioner, ma'am.
Mr.
M. Ratan.
Learning Counsel for the petitioner. You have obtained consent from the other side.
Yes, ma'am.
Okay, with the consent of the other side. Raise for adjournment of the matter for the day. We are allowed. List this matter after 2 weeks.
3 weeks.
3 weeks. Okay.
My lord, interim is there.
The interim order passed earlier shall continue till the next date. Okay.
Deeply obliged.
May I please, Your
Yes.
Lordship? I beg to mention item number 19, my lord. It's a hearing matter. So analogous matter has already been fixed after vacation, my lord. Analogous matter. So it may be also fixed after vacation, my lord.
Mr. Udeka, Learning Counsel for the appellant. Some said the analogous matter has been fixed on
On after vacation, my lord.
after vacation.
Yes.
Accordingly, pray for listing this matter along with the What is the number of analogous matter?
15, make appeal 15, my lord.
Along with the
What-
make appeal, no, no. This is make appeal 15. What?
16, my lord,
Okay, make
16,
appeal
yes,
16.
16 has been pending.
After the entry summer vacation.
Yes, my lord.
Okay.
Your Lordship, I beg to mention
Clear,
item number 12.
Please see that accordingly.
Item number 12. So,
Yes.
with the permission of this Honorable Court, I taken a fresh step on 16th of May. With the permission of this Honorable Court, I have taken a step in respect of respondent number.
We'll see the record and pass order. This is in order. Let us see the office note and pass order accordingly.
Your Lordship, it's awaited. Service.
What?
Service is not completed till yet.
That is why we'll see the record. We'll pass order. It is in order.
Okay, Lordship.
In the order, we'll see the office note. Thereafter, we'll pass order.
Okay, Lordship.
Okay. Okay. Wait for some time. Yes.
My lord, I beg to mention item number 10. The conducting council is out of station due to medical crowd. I have taken the consent of the respondent number 2.
Maybe, but let us see. We'll pass order. Adjourn, but then let us see the office note. Then we'll pass order. Okay,
Okay.
wait for some time. Yes.
Your Lordship, I wish to mention item number 20. I'm appealing on behalf of N. Sharma, petitioner. I have taken consent from other side.
I appear for the private respondents in this case.
Okay.
I'm for the state lawsuit.
Criminal petition. So what do you want?
Your Lordship, kindly this matter may be fixed for 4 August.
Fix for
4 August.
4 August.
Fine.
Okay. Mr.
Sita Jo.
Landing counsel for the petitioner. Praise for adjournment of the matter to be fixed on 4th August, to which Mr. B. Nair and Mr. L. Hage, appearing on behalf of the respondent, has no objection. Accordingly, the prayer is allowed. List this matter on 4th August. Okay.
Much obliged.
My lord, I would like to mention for the withdrawal of the case, my lord.
Okay. What is this matter about? You want to withdraw?
Yes, ma'am.
Okay.
I want to withdraw. My lord, yes, ma'am.
Okay.
My lord, withdraw with liberty to file a press, my lord. Please kindly.
Okay.
Much obliged.
Yes. Okay. Okay, after. Then we'll continue at 2. Special PP, SIT. Okay.
Yes, yes, fine.
Deeply.
Okay. 23. On 23, huh?
25th. 25th.
Yes, 25th.
Yes, yes.
Yes.
That has been passed by the Deputy Commissioner. My lord, here the prefect of the case is there. Commissioner had a mission which was gifted to him by his brother-in-law sometimes in the year 2008. The petitioner, he had a, so that was gifted to him as a private.
There was some,
Yes.
see the request for some time to that matter is under discussion for settlement. Whether settlement done? No,
No, Your Lordship.
it failed.
Yes, Your Lordship.
Marriage of 2031, what survives? It's about the Mithun, okay?
Exactly, Your Honor. Even there was on third occasion, Kabang was held. And in Kaba, the fine was also imposed to the petitioners
Then
for making false allegation against me.
Otherwise,
Your Lordship, the order is Your Lordship.
Okay.
My lord,
Party, just a minute, yeah. Party wanted to settle the matter. Well, no report thereafter it appears. How many respondents are there?
um,
Total respondent, they made an endeavor to settle. Whether tried.
my lord, may come, kindly come to page 36.
Page
36. This is the order that I put to tell him. My lord, I'll just read the operating part here.
just a minute. 33,
36.
36.
Last pair I will, 36 last pair.
Read all. I haven't seen. I thought that this party must have settled.
Okay.
Hmm.
There
Yes.
there is the appeal petition filed by Sri Isran Eckers, son of Sachin sir, against the Sabha decision dated 29/7/2008. And in the letter of Sabha decision dated 18/9/2012, 2016 and 17/4/2017.
What is the Kaba decision?
Sabha decision, your lordship, the Sabha.
Where is the Kaba decision? Decision first. Or if it is going to take some time, what we can do is we can fix it for hearing. Then both the parties, because they failed. We'll fix it for hearing.
I know.
Okay.
Yes.
Since whether the record was called for,
No, my lord,
record not necessary.
not necessary. My lord, I'm just challenging the ground by which the deputy commissioner has passed this order.
Maybe, but this, it appears that disputing the fact, it appears. It is.
Yes.
My lord, facts are not disputed at this point of time.
Then what is disputed?
Your lordship, the grounds by which
Okay. Okay, just where is Kaba decision? Okay.
the Prabhat decision is type copy in page 29. Page 29, type copy. Annexure. Annexure 4,
Page
29.
this is Kaba decision.
Yes, your lordship, there were series of Prabhat.
Long Kaba decision.
Yes, your lordship.
Where is the operative point?
Point number.
Point number?
operative portion is point number 5, your lordship. The government, page number 30, point number 5. Sri Gamini Padu has stated that Sri S.N. Mehta had not limited to the allegations of stealing, but rather had filed a complaint against me before the police, and the DC Sohi demanded compensation from Sri S.N. Mehta for his expenditures and loss of work hours. Despite his submitted demand, the cover orders Sri S.N. Mehta to compensate by means of paying a Mithun of rupees 50,000 rupees only, if paid in cash to Sri Gamini Padu. So, your lordship, the ownership of the Mithun was also declared in favor of the respondent, and also, your lordship, the petitioner, he was further directed to pay a sum of rupees 50,000 as a compensation to the respondent. This is the ground I'm challenging before the deputy.
You are Gamini Padu.
No.
You
I'm
are?
S.N. Mehta, the petitioner. So it has went again against me. That is the reason why I have filed an appeal before the deputy commissioner.
File and content. Yes. Before the previous conditions. Other. Whether this is decision or this order was passed in what? Appeal. This is Gaba order.
Cover order, Your Lordship.
No, whether earlier there was one more Gaba,
Yes,
it says
Your
only that despite,
Yes, Your
see,
Lordship.
despite his submission, despite his submitted demand, the Keba order Sri so and so to compensate by means of paying, where is that Keba order?
That is.
Means
Your
of paying, see, another Keba. See, I think it take long time. You think that this is short enough?
There is one cover decision, Your Lordship.
See, going back Keba, where is that one?
Mm.
See, you should start from first Keba.
Take. Otherwise, may I Lordship, may I narrate the facts briefly? May I narrate the facts briefly? For.
See, that is why I'm saying it will take long time. So we are in the second afternoon, you see, after 2. We will not be able to spend much time on this.
Your Lordship.
So we'll fix it for hearing. Long hearing will give enough time to both the parties. Okay?
Your Lordship.
Then admit it and fix it for hearing.
Yes.
Okay. Hard miss. You are miss?
Even.
Land counsel for the petitioner. Also have Mr. K. Lolen, land counsel for the respondent, staff. Upon hearing the parties, it appears that the matter requires a deeper consideration. Accordingly, the petition is accordingly admit the petition. List this matter for hearing after 2 weeks, 3 weeks.
Your
Okay.
Of life.
Quickly of life.
May I come? It was heard last time. my lord. Yes, and accidentally, my lord has given me the right course of argument, my lord. So I will give it to it, my lord. My lord, may I please come to page 23, my lord, the Keva decision.
Page
23, my lord, type translated copy. Yes, my lord. May I read, my lord? Page 23.
Yes, 15 days.
Yes, my lord. So by this cover decision, my lord, a substantive right was created in my favor, my lord.
Yes.
My lord, I would like to read para 4, my lord.
Given
If Sri-
15 days.
Yes, my lord. The sentence would be, my lord, would be.
Yes, yes, please.
If Sri Obhyadaya did not agree the boundary shown by Tasung family, then he can within 15 days recall a cover. And if thy family will not call a Kaaba, then from the date of so and so, as per the boundary land shown by Tasung family, the land shall be upheld in favor of Tasung family. So I was given a substantive right to recall the Kaaba. Now what I did, page 26, the translated copy.
26 is your complaint.
My lord, yes, my lord.
Just a minute. Okay, you have filed in the
Yes,
form of
my lord.
complaint.
Yes, what has given me substantive right to recall the Kaaba. So by this complaint, my lord, I have filed a complaint for washing aside the Kawang decision, my lord. May I read, my lord?
Yes.
Complaint against ex parte decision passed by you and so on, sir. But sir, by this note letter, I am to inform you that Sri Tamu Tasung has without any authority and right has earth cutting at my so and so for that my wife has lodged a complaint at Pasigat police station. And after verification, police has registered the case number so and so, against Tamu Tasung dated so and so. So therefore, without court order of the said case, the Gaupura cannot pass a Kawang decision. Therefore, you quash and set aside the ex parte order. So I was given the substantive right to recall the Kaaba. So I have prayed for quashing and setting aside the Kawang decision, my lord. Now this was my mistake, my lord, which has been taken care by the Gaupura, my lord.
Therefore, without the court order of the said case, the Gaupura cannot pass a Kaaba decision.
Therefore, you quash and set aside. So by this complaint, my lord, I have prayed for quashing and setting aside the Kawang decision. Not for recalling which has been taken care by
28, what is 28?
28 is my rejection, my lord, since I have not prayed for recalling of Kawang.
Okay.
So on that line, my application was rejected, my lord. My lord, may I read, my lord, page 28.
So the language matter.
Yes, my lord. But they are one and same, my lord.
Oh.
But here the interpretation has been given by the GB that I have not prayed for recalling of the Kawang. That is why he has rejected my prayer, my lord. May I read, my lord?
Yes.
I have received your letter notice also, and as a reply, I am to state that in earlier occasion also, so when the you were not present, so and so. However, you were not present. Therefore, on 19 so the Kaaba attended GBs and public has decided that within 15 days, Sri Abhidat has to call a Kabang. I have to call a Kabang. Though you had not called the Kabang. I have not called a Kabang. I have only prayed for, I have filed a complaint for quashing and setting aside the Kabang. So they say I have not called for the Kabang. Now, before going to the
Okay, recall the is not says that recall the order, but call says that recall the Kaaba.
Yes, ma'am.
So he want another.
I should have filed a representation for recalling of the Kaaba, not for causing a side. Oh, one thing I want to.
There was only one GB.
Yes, ma'am.
Who decided that?
Yes, my lord. I would like to ask my affidavit in reply, my lord. Only that part, my lord.
Since you have not called the Kaaba.
Yes, my lord.
Therefore, I will not change the decision.
Yes, my lord. I have prayed for quashing and setting aside. For one thing, my lord, I want to submit, my lord, why I was not present on 19/2/2020, my lord.
one thing on part. Given,
Not present when?
yes, my lord, on 92/2020.
Okay, on the
Kavang
date,
decision,
on the date of Kava decision. Ex parte decision only?
Yes, yes, my lord.
Okay, but then you have.
Just I
to-
want to show, my lord, why I was not there. Just go to
Page,
page 40 of my F.
page
40, my lord.
40.
Yes, my lord. Circular, my lord, dated 17/2/2020, my lord.
Yes.
Yes, my lord. May I read, my lord? This is a circular issued by the Deputy Commissioner of the Upper Siak District. As discussed and decided during the coordination meeting dated so and so, a joint social service will be conducted on 19/2/2020, my lord, from so and so hour. So was, my lord, I was there at Upper Siak, my lord, for, my lord, this social service activity, my lord.
You are?
I am a staff, my lord, of Upper Subansiri, sorry, Deputy Commissioner District, my lord, office of the,
Working in the,
Yes,
in the
ma'am.
office.
yes, my lord. So because of the reason, my lord,
Why
I
you are
could-
showing this?
just to give my lord, why I was not present, my lord. There was a reason, my lord, I was not present.
Is that required?
Not required, my lord, just want to show
Is
my.
there any limitation comes? No.
No, my lord. Now, my lord,
Then not required.
now, my lord. Now, my lord, what I am submitting is that, my
Hmm.
lord, the Kavang decision, my lord, has itself given me a substantive right, my lord,
Yes.
in para 4, my lord, for
Hmm.
recalling of the Kavang, my lord.
Hmm.
But instead, I have prayed for quashing and setting aside of the Kavang, my lord.
Hmm.
So there are some procedural lapses, my lord.
Hmm.
What I am submitting, my lord, substantive right, my lord, accrued to a litigant should not be defeated, citing procedural defects capable of being cured. So I will be relying on the judgment, my lord. May I, my lord, 1969 1 SCC, my lord.
Yes, that is, you were given an, right, you were given an opportunity,
Yes, my lord.
15 days,
Yes, my
and
lord.
according you filed, and that was rejected.
Yes,
Then
my
what?
lord. For quashing and setting aside, my lord.
Yes, you have filed, but that was rejected.
Yes, my lord. Because I
next
have
what?
not prayed for recalling of Kavang, my lord. I have prayed for quashing and setting aside, my lord. Since this is only a procedural.
So that
defect.
was rejected.
Yes, my lord.
Hmm.
Only on the ground that I have not prayed for recalling of the Kavang, my lord. Subsequent was the second impugn order, my lord.
Hmm.
What I am submitting is that, my lord,
No, but whatever may be,
my lord,
but this is a rejection of your application.
my lord, but
The 15 days time given
Yes.
to you.
Yes, ma'am.
And you have availed that,
my lord,
and that application has been rejected by this order.
yes, my lord, because I have filed wrong application, my lord. Because I have filed wrong
Where it
application.
says that it's rejected because of wrong application?
Because I have not called for the Kavang, my lord.
Kaba.
Yes, my lord, that is the wrong application, because I have prayed for quashing and setting aside of the Kavang, my lord. Not for recalling of the Kavang, my lord. That is my case, my lord. Accidentally, my lord has last time observed that, my lord.
Hmm.
So I have taken that ground now.
Yes.
My lord, I will satisfy, my lord. This honorable court can interfere, my lord. My lord, may kindly see 1969, my lord, 1 SCC.
Because quashing should
Yes.
have been before the higher court.
Yes, my lord. The language, this is the, my lord, wrong language that I have used. Because of that, it was rejected, my lord.
Okay.
Yes, my lord. My lord, para 5, my lord. Para 5, yes. The order passed by the High Court cannot be sustained. Rules of procedure are intended to be a handmaid to the administration of justice. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. Now, my lord, 2006 1 SSC, my lord. Yes, my lord, yes. My lord, para 17, my lord. 17, my lord.
Yes.
May I read? my lord?
Mm.
Non-compliance with any procedural requirement relating to a pleading, memorandum of appeal, or application or petition for relief should not entail automatic dismissal or rejection unless the relevant statute or rule so mandates. Procedural defects and irregularities which are curable should not be allowed to defeat substantive rights or to cause injustice. Procedure, a handmaid to justice, should never be made a tool to deny justice or perpetuate injustice by any oppressive or punitive use. Now, my lord, 2022 7 SSU. This has been evolved time to time, my lord.
For the same point.
My lord, yes, my lord, but it has some significance, my lord. Para 15, my lord. Because it has been evolving from time to time, my lord. Para 15, my lord.
Yes.
My lord. It is straight law that the procedural defect may fall within the purview of irregularity and capable of being cured, but it should not be allowed to defeat the substantive right accrued to the litigant without affording reasonable opportunity, my lord. So, my lord, what I am submitting, my lord, let the Kawa decision, my lord may not interfere with the Kawa decision, my lord, but my lord, this rejection, my lord. My lord may interfere with this rejection and allow me to file a fresh application, my lord, for recalling of the Kawa. This is my prayer, my lord.
Okay.
Obliged.
Yes. What about that? Subsequently, they have filed execution petition.
Execution petition is not maintainable because it is before the authority without jurisdiction, my lord.
But there is an order there was an order already passed in execution petition.
No, my lord.
No,
That is
but-
without jurisdiction, my lord. That is without jurisdiction, my lord.
You are not challenging that.
Item number 4, my lord. I've challenged it.
Oh, that is separate.
Yes, my lord. I have also challenged here, but item number 4, actually, I filed first item
By
number
the
4.
same person,
Yes, my
the
lord.
petitioner.
Yes, my lord.
What is different there in item number 4?
Item number 4, my lord, because, my lord, the civil code act came into effect, my lord. Meanwhile, even though civil court came into effect, they have filed application before the district judge, my lord.
No,
But
but item number 4 is in continuation of this item number 5.
Yes, my lord.
Sorry, item
Same, because item number 4, my lord, I have filed first item number 4, I have first filed them. Item number 3, my lord, I have filed later, my lord.
Okay, so that means
Item number 4 is specific
item
for,
number 3 is continuation of item number 4.
my lord,
Item number 3, same only,
Same.
challenging the same order,
Same.
same impugn order.
the same, no, my lord. Item number 4, my lord, I am only against the execution order passed by the district judge, my lord, which has no jurisdiction, my lord. It is the deputy commissioner who has the jurisdiction to entertain execution petition.
Can be taken up together only,
Yes, my lord.
and an order can also be in the.
Yes,
same-
pass. Yes, ma'am.
Okay,
Same and order. Yes.
so
Yes.
yeah, in item 4, your only contention is that the deputy commissioner doesn't have any jurisdiction.
Well, district judge
Sorry, district judge.
does not have.
But the district judge referred to the deputy commissioner with some direction.
Yes, by exercising his as a power of execution court, my lord. So it does
So
not
he
have.
doesn't have execution.
No,
power.
my lord. Yes, ma'am.
But
Which they are also conceding
No, so what his direction was to
to demarcate.
forwarding the deputy commissioner to engage any executive magistrate
Yes, my lord.
to demarcate
Yes.
demarcate the lane.
Yes, my lord.
So he doesn't have that power.
Yes, my lord. He does not have the jurisdiction, my lord.
Okay. And then pursuant to this direction of the district judge, whether the executive magistrate or the deputy commissioner is already engaged probably.
My lord, we have state, my lord. This honorable court has state, my lord.
Oh, that is, okay.
State.
understood. Okay. Then
My lord, yes, my lord, only one thing, my lord. My prayer portion, my lord. So, my lord, what I am saying, my lord, my prayer, my lord. Prayer number 1, my lord, may not interfere
in
with.
which?
Yes, my lord, in item number 3, my lord. Item number 3, my lord, my prayer for, my lord, for interference of the Kavak decision may not be interfered, my lord. Kavak decision, my lord, I am foregoing my prayer number 1, my lord. Let it be remain, my lord. Page 16, my lord. Yes, sir. I will not be.
Prayer number?
1, my lord. Page 16, my lord. I will not be pressing for, my lord, the quashing of this impugn order, my lord. Kabak decision, my lord. Page 16, prayer number 1. I am giving up this prayer, my lord. I will be only praying for prayer number 2, my lord. For quashing and setting aside the communication that the 16.3 so and so. And my lord, I may be allowed.
What is this 16.3?
This is the rejection, my lord. My rejection. Rejection by the GB, my lord, which I have filed complaint and GB has rejected my application, my lord. Because I have not prayed for recalling of the Kaba, my lord.
So you want to recall the Keba? You want, huh?
I want to file fresh application, my lord. Because I have
Okay,
not prayed
press
for.
application as per the order of the Keba.
Yes, my lord. That may be allowed, my lord. That is my prayer. Because due to only this procedural defects, my lord, my substantive right cannot be curtailed. My lord. The Kaba decision is final. It has given me some certain rights, my lord. But due to the word used by me for quashing and setting aside, my lord, my right, my lord, substantive right has been curtailed. So, my lord, for the defects which are curable, my lord, my substantive rights should not be defeated.
Okay.
Yes.
Anything else?
No, my lord.
Okay. Yes, yes, Mr. Tahir.
Yes,
Oblige.
yes, my lord. There is no any such defect. But what he tried to submit is that see, the Kaba decision is very clear, your lordship. The Kaba decision in the para 4, again I will go. It says that within 15 days to recall the Kaba. Now the letter dated 16/3/2020, your lordship, it clearly says that he didn't file a petition within 15 days. So the Kaba decision has become.
He filed a wrong petition.
No, not wrong petition, your lord.
He filed a complaint within 15 days only.
15 days, but that was regarding
That is for quashing.
for intimation about a police case, which has been registered in the
No, no,
Pasigat.
says that since there is a police case,
Yes.
unless there is any order from the court,
Court.
the Keba
Yes.
that doesn't have any power.
Power.
Or cannot
But-
cannot
but
decide the matter.
Decide. But your lordship, there is two parallel jurisdictions, criminal cases something else and civil cases something else. So the Kaba cannot be barred from taking up the civil disputes, even if there is a police case pending.
That is why he is praying
Yes.
that he may be allowed to file fresh application.
No, there is no.
In terms of the Keba order.
That
Keba's
that
order.
your lordship may kindly see that the rejection order of the Gaura.
Yes.
He says that he didn't file a petition to recall the Kaba within 15 days.
Yes.
So will not recall any Kaba now. So it is attained finality.
No. What he says?
He says that
No, I will not change the decision. Only
Yes.
says, I will not change the decision.
the Kaba attended GBs and public has decided that within 15 days Sri Obyadda has to call a Kaba. Though you had not a call a
No,
Kaba.
he says that I will not reconvene the same Keba.
Yes.
Okay.
Therefore, I will not change the decision passed on so and so.
Hmm.
I will not convey the same Kaba.
Hmm.
And your Honor, yes, it is truly said that the Kaba cannot again reconduct once decision is passed. There is no provision for reconducting another Kaba.
No, no. So here, suppose had he filed a proper application,
Yes.
he was ready. The order itself allowed him to file.
No.
Had he filed proper application for recalling of
No,
Keba, then he would have
Yes.
conducted.
The time period was given,
Mm,
15
yes.
days.
But he has filed wrong application.
No, yeah, that
Informed-
he has not said that, but he says time period of 15 days
No,
was
the
given.
order didn't say, but then the petitioner
Yes.
filed the wrong application.
No, for that his wrong application, Your Honor, I should not suffer. the respondent should not suffer. That is the wrong, he is not a layman. He is an official, a government employee. He knows everything. And you will find that how he neglected in this case also. From the very beginning, since 2020, the Kaba decide was 19 to 2020. He slept it over till 23. He didn't take any interest, despite deliberately knowing all those things. Taking the plea of COVID, we can 2020 to 21, Your Lordship. Then thereafter also he didn't make an attempt. No attempt was made. There is a deliberate act.
Okay, anything else?
Yes, Your Lordship. Then now when this has attained its finality, Your Lordship, so the remedy would only be through that, even if this we can say that suppose he filed an application for setting aside that Kaba decision, then also he should, if that is rejected, then it becomes final, and he should go for an appealable order only. The rejection itself is an appealable order. So he should go to an appellate forum only. And to avoid that delay of this many days, he has avoided the appellate forum and is approaching this honorable court in the form of CRP. My contention would be that, Your Lordship, the petitioner has not filed any application for setting aside. That we cannot say that is for setting aside. And also to recall, no application was filed. This was just for intimation regarding a police case. Therefore, Lordship, I'll rely upon two judgments of this Honorable Supreme Court, though the facts are different, but the ratio of the law is that when Article 227, I could not to entertain a revision application challenging the ex parte judgment in degree as there was a statutory alternative remedy by way of an appeal available.
Para?
Lords, that is in 7, not 7, is 8. Yes, 7. 7.
This is regarding?
This is regarding the this pertains to a case in connection with this for setting aside judgment and degree.
Yes, what it says.
Yes, when in the said decision it is observed and held by the
Which paragraph you are reading?
7, Your Lords.
Para 7?
7.
At this stage?
Yes.
Yes.
In case of yes, in case of such is required to be referred to
Where?
the para 7 here.
Para 7 of
The entire para, Your Honor.
6 points.
Yes. In the said decision, it is observed and held by the court that whenever proceedings are under the code of so-and-so and the forum is civil court, the availability of remedy under CPC will deter the High Court, and therefore the High Court shall not entertain the revision under Article 227 of the Constitution of India, especially in case of where a specific remedy for appeal is provided under the CPC itself. While holding so, it is observed and held in para 11 to 13 as under. So then 7.1 the other. Yeah, there it is. Secondly, the High Court ought to have seen that when a remedy of an appeal under section so-and-so of the CPC was directly available, respondent so-and-so have to have taken recourse to the same. It is true that the availability of the remedy of appeal may not always be a bar for the existence of supervisory jurisdiction of the High Court.
You are reading which paragraph?
In the 7 para only below.
No, continue.
Yes. It is well recognized principle which gained judicial recognition that High Court should direct the party to avail himself to such remedies before they resort to constitutional remedy. But courts should always bear in mind a distinction between cases where such alternative remedy is available before civil court in terms of provisions of CPC and cases which such alternative remedy is available under special enactments and or statutory rules, and the fora provided therein happen to be quasi-judicial authorities and tribunals. In respect of the cases falling under the first category, which may involve suits and other proceedings before the civil courts, the available appellate remedy in terms of provision of CPC may have to be construed as a near total bar. Otherwise, there is a danger in the so-and-so. You know, here also, there is a, in Arunachal Pradesh Civil Court Act, there is a provision for appeal and also to go for de novo trial. Or 7 and 8 years.
Yes. So according to you, that there is an alternative remedy,
Yes.
that is appeal.
Yes.
Since the petitioner having not filed appeal, the civil revision doesn't lie against the impugn order. Yes.
Yes. Yes. Lord.
So,
I would like to submit one rejoinder.
this is another.
The execution petition,
227.
Lordship,
Yes.
the execution petition may be remanded back to the proper forum. That's will be our prayer.
Remanding back is nothing, my lord. They have to file application before. My lord, I want to submit one rejoinder. My lord.
Yes.
My lord, my lord,
Counsel for the petitioner.
I would like to submit it.
What is that?
Yes. My lord, what I am saying, my lord, I am again submitting. I am not praying for now, my lord. I have forgone my first prayer, my lord. I am not praying for quashing and setting aside of the Kavang decision, my lord. I am only praying for allowing me to file a fresh application, my lord, so that the substantive right which Kavang decision has given to me, my lord, I want to, my lord, take benefit of it, my lord. My lord, there is no prescribed procedure in the process of, my lord, conducting Kavang, my lord. My lord, whether recall, whether given 15 days time or so, there is no such process, my lord. Kavang takes its own course, my lord, the village authorities, my lord.
Also,
Even my lord, CPC is not applicable.
Land counsel for the land counsel is hearing on behalf of the respondent. So I'll pass over the chair. Okay.
Regarding the delay, my lord, in para 14, I have stated part. Para 14 of my civil revision, I have explained my delay, my lord.
Yes, this is probably. Okay, let us see. Yes.
This is my prayer, my lord. Even he will win, I will also win, my lord. This is my prayer, my lord. He will also win, I will also win, my lord. That is my prayer, my lord.
I have no idea. Yeah,
Alright.
this one, this thing. Yes.
May I, my lord?
Yes.
My lord, this is a joint petition for quashing of my lord. Nari Police Station case number 02 of 2016.
What, please, Nari?
Nari Police Station case number. My lord, petitioner number 1, 2, 3 are the accused and brothers, my lord, and petitioner number 4 is the wife of the petitioner number 1 is a victim of the case, my lord.
Who appears for the state? Who is appearing for the state?
Item 6.
Your lordship.
Okay, what is the allegation?
Allegations, my lord, FIR is in my lord. Page number 29 is the type copy of FIR, my lord. Is matrimonial dispute, my lord. May I read, my lord?
Yes.
Sir, with due respect and humble submission, I, Srimati Migna Doke GC, have the honor to state you that I have been physically and mentally assaulted by my husband Sri Gobi Doke, JT Government Middle School Name, since the birth of my first son, Vigan Doke. I have been a victim of domestic violence between two families. By customary law, our case has been settled, but still domestic violence going through. But on 15/3/2016, Sri Gobi Doke, husband, Goki Doke, brother-in-law, Sri Gomar Doke, brother-in-law, has physically assaulted me with grievous injuries to my whole body. Therefore, I, Srimati Migna Doke, with full conscience, request you to launch book on FIR on domestic violence against it on your respected FIR book. This is the allegation.
Okay.
Thereafter, my lord, Keba was held, my lord, on.
After this FIR?
Yes, after this FIR, 3 days after FIR, I think, on 27/03/2016, my lord, a Keba was held, my lord. Annexure number 2, my lord.
And there
Page number 31 to 34.
Where is the type?
Type of copy is 33, start from page number 33, my lord. May I read, my lord? Here, my lord, the presence of, in presence of village elders and GVs, they have settled the matter amicably, my lord. Therefore, they also submitted application for withdrawal, my lord. Application, my lord, is in page number 35 to 36, annexure number 3. 36 is the type out copy.
Just a minute.
Yes, my lord, may I read, my lord?
Just a minute. Just you right. Hello. FIR, yeah. Point right. One FIR was closed on 25/3/2015 and 2016. case registered under section 498K IPC. Okay, next. After 3 days, on 27/3/2016, Keva was held. The Keva says that there was one verbal altercation between wife and husband. Case settled. And where is the withdrawal?
Yes, application is page number 36 type of
This
copy.
was
Which
on
was
when? This
filed
was on when?
It was filed by victim and the other GVs
Okay,
were
when? Date?
dated, my lord.
Next page, thereafter. The
That is not clear.
informant made an application before judicial magistrate first class for withdrawal of case. Okay.
As per the receipt of OC is 30 March, my lord.
30 March.
Yes, my lord.
On 30
Page number
March.
35, my lord.
Okay. Okay, now what is the, then thereafter?
Thereafter, my lord, during hearing, my lord, at the time of hearing on instant petition on 12/02, my lord, 2025, issue of lack of formal deed of settlement was raised, my lord. Issue of lack of formal deed of settlement was raised, my lord. Therefore, the petitioner has
No.
so time for execution of proper deed of settlement between the parties, and it has been executed and submitted by way of additional affidavit, my lord.
What?
Additional affidavit, which is
Additional affidavit means?
yes, I have filed additional affidavit.
Here in this case?
Yes, my
For
lord.
what?
So to bring the formal deed of settlement.
Oh, thereafter settlement also.
Yes, it was made after filing of this criminal
Thereafter
petition.
case was charge sheeted.
Case was yes, my lord. It was charge sheeted on.
May your lordship.
Yes.
During actually, your lordship, by virtue of the Kaba decision, they approached this court.
Okay.
So during the pendency, this court has directed to enter into a formal settlement.
Okay, okay.
So they have entered into a settlement and filed this additional affidavit.
Okay, that is there.
Yes.
Okay, what is the status of the case?
Status, your lordship.
Charge sheet filed before the court.
Yes, and was
No, there is stay was there, your lordship.
No, no.
the charge sheet was
what
filed.
the state?
TCR was called for, man. TCR.
Then
Meaning
charge
you have
sheet must have been
charge sheet filed.
Charge sheet was filed on 25/05/2016.
25?
05/2016.
Okay, charge sheet filed on
Yes,
05?
25/05/2016.
TCR is there, my lord.
Okay, 05.
Charge sheet number 07 of 2016.
Thereafter, whether the case was registered before the court.
It's never been come for trial, my lord. Only charge sheet was filed, but never called for record trial, my lord.
Now, if the charge sheet has filed, then case must have been taken cognizance of and registered as a GR case number so and so. Where have you mentioned the GR case? Because it's no longer with the police.
No, my lord.
Now,
Yes, we
the case is
obtained
no
it.
longer with the police.
We obtained it from police station.
What is that?
This- charge
No,
sheet
what is the number, registered number?
Charge sheet number is
Case
07.
number, case number in the, before the court. Now, the case is not with the police. It is before the court. What is the case number? You have? Do you?
I will find out from the record,
Please.
my lord.
Yes. The accused was never been summoned in this
No, no.
case, therefore,
So
my
what?
lord.
So what? But it was
GR,
charge sheeted.
GR number 2 of 16, my lord.
Okay.
Nari PS 2 of 2016.
Any cognizance taken?
Your Lordship,
Any someone issued, charge framed? Okay, charge, submitted, charge it on when?
2505.
Okay, and registered, court taken cognizance on, cognizance.
Your Lordship, cognizance. I have not only.
Okay, go on. Yes, GR number.
My
02
Lord,
of 2016.
yes, Your Lordship. 2 of 2016.
2016.
Before Your Lordship, Chief Judicial Magistrate.
Chief Judicial Magistrate.
Isyang.
Isyang Alo.
Pasigat.
Oh, Pasigat, sorry.
Yes, Your Lordship.
Pasigat, okay. Pasigat, and then settlement when you said? Deed of settlement by filing?
Recent settlement, my lord. It is in page number.
Parties mutually settled the case on.
75, page
on-
number 75, 76, on dated 05/03/2025.
05/02/2025, okay. So you have any objection?
No, my Lord.
Okay.
498A. No objection, my Lord.
That is, yeah, Kapna, I'll pass order.
Yes, Your Lordship.
Deeply obliged.
It goes. To be dictated, huh? This is item. Okay.
May it please your lordship.
Yes.
Lordship, this is appeal against a judgment convicting me to 10 years imprisonment, RI under the NDPS Act 21B2, my lord, 21B2C of the NDPS Act, RI of 10 years and 1 lakh rupees fine. In default, 3 months. My lord, this is a case in which the procedure was not followed, my lord. Firstly, my lord, I was not given any opportunity to adduce defense witness. It's a violation of section 233 of the CRPC. The judgment also does not reflect that I was given any opportunity to adduce evidence. Secondly, my lord, there was
No. Have you seen the 313?
313. In 313, my lord, I was not asked about
That-
ask.
Have you annexed?
313, I have not annexed, my lord.
Okay.
It is, I do not have it with me, but my lord, the
Record need to be.
record is needed.
Okay.
Further, my lord, there are certain other aspects. My lord, this is a case of no evidence, actually, in reality. My lord, because from the judgment itself, it will be clear, my lord, that the learned special judge, my lord, relied on a purported confessional statement. If my lord comes to para 27 of the judgment, at page, my lord, (27) 120. Page 120, my lord, para 27.
Yes.
I have also perused the confessional statement of A2 Banti Singh, recorded by JMFC UPI as provided under section 164 CRPC. Well, the rest lordship may not go through at the moment. Now, I'll take lordship to para 56 of the judgment at page 132.
Para?
56. 132 page number.
Yes.
It is also observed that the defense could not rebut the case of the prosecution to prove their innocence as provided under section 54 NDPS Act. It is to be noted herein that though A2 has confessed and his confessional statement is recorded in the present case, but the same is not exhibited by the prosecution and it is not considered while preparing this judgment. It is not admissible in evidence. It is not even exhibited. Now, my lord, the ganja was seized from accused A2. It was seized from a room which I had rented. It was my tenanted premises. Yes, my lord. But accused A2 is a driver. He is my driver. I had asked him to stay there. the ganja was seized from his possession, not from my possession. The confessional
So
state
driver is accused number,
accused to Banti Singh.
he has been convicted under,
He has been convicted. Same. And if Lordship goes through the entire judgment, it is his statement that the ganja was provided by me, but it is seized from him. I was not there, my lord. The confessional statement is not admissible. So how can I be relied on? There is no other eyewitness who says, or any other witness who says that the ganja was seized from my possession. There was violation of section 52, though that has been discarded by the learned special judge, but violation of section 52A of the NDPS Act. My lord, this is at para 51 of the judgment. Para 51, Lordship will find that page 130.
yes,
The first line. In the present case, though there is no compliance of section 52, but the prosecution has substantially proved that the contraband substance was seized from possession of the accused persons, and the seized materials produced before this court are material evidence, and there is no doubt regarding the seized materials. Now, the learned special judge himself admits that there is violation of section 52. 52A of the NDPS Act. So there are other aspects also, but I'll not bother Lordships with that today. The TCR has to be called, my lord.
yes.
And my lord, what I would pray for, my lord, there is a suspension application. Now, this lady is 65 years of age. If I have filed one additional affidavit, she is now under treatment in TRIMS. I have filed one additional affidavit today, my lord. If my lord takes up the additional affidavit, it has been, it is there. Thank you. If
Yes, call for,
my lord may come to the
just a minute.
last, the second last.
Probably here also we have to give notice.
Or here notice has to be issued. But my lord, at page 7, just for a moment, if Lordship sees.
Page 7 or?
Page 7 of the additional affidavit, my lord. Filed today, my lord.
Additional affidavit.
Affidavit filed today, my lord. Filed today, my lord. Additional affidavit in the IA filed today. Page 7, annexure 2. Lordship will see. Page continue where? Oh.
Then it will be
Oh, I'm sorry, my lord. It will
Yes,
not be
that is right.
10, then 11, 12, 13, 14, 15, 16, 17, my lord. Page 17, annexure 2 of the additional affidavit.
Okay.
Lordship sees it's that of the TRIMS, my lord. Lordship will see my age recorded, 65 years. And
You will tell so many things. He can say 85 years also. What is the age shown in the judgment by the way?
in the judgment, my lord, it is down below, but I have annexed my Aadhaar card as well. In judgment, it is 53 years. And in the charge sheet, it is 46 years. In the, my lord.
Now, what is your actual age?
65, my lord. 65. My lord will see my Aadhaar card, my lord, at page 28 of the memo of appeal. 28 of the memo of appeal. My lord, I was born on 12/3/1960. It is 65, my lord. Okay. So, for the treatment, if my lord be considered, there are glaring discrepancies in the judgment, my lord. This judgment, in my humble submission, would not sustain. And I have not been convicted under 120. Neither has accused Banti Singh.
Oh, okay, so both are involved.
My
120.
120 charge has been framed. The order framing charge is at page 91, my lord. Charge has been framed under 120
also.
120B also.
120B.
But there is no conviction.
Okay, no discussion also.
No discussion at all. It's a glaringly, my lord, this, in my humble submission, this judgment cannot survive. The conviction will not survive, my lord. Page 91, my lord, the order framing charge. Lordship may say, hence accused Nuri Yai and Charu Mala, charges framed under section 20 so and so NDPS, and against accused Yowa Are and accused Banti Singh under section 120B, read with 20B2C. There's no discussion in the judgment of conviction under 120B. If I'm not convicted under 120B, how can the learned trial court convict me along with Banti Singh, from whom it has been seized, my lord?
Yes.
Yes, with regard to the additional lordship affidavit, the phase 6, the ailment they claim to be suffered from lordship is headache.
Mr.
Is
You deny it?
No.
You deny land counsel for the appellant. Para. This is an appeal filed under section 415 within bracket 2 of the BNSS as a Bharatiya Nagrik Suraksha Sanhita within bracket BNSS from 2023. Radio section 36B, capital B of the Narcotic Drug and Psychotropic Substances Act 1985. Challenging the judgment in order dated, a judgment dated 23/4/2025 and order of sentence dated 28/4/2025 passed by the Learned Special Judge NDPS, UPR. In NDPS and in special NDPS case number 04/2018, whereby the accused appellant has been convicted for offense under section 20B within bracket 2, Roman 2, within bracket C of the NDPS Act 1985, sentencing to undergo rigorous imprisonment for 10 years and a fine of ₹1 lakh and in default of with default clause. Stop. Call for the trial court record, issue notice, since Mr. Roy appear and accepts notice on behalf of the state respondent. No formal notice need be issued. You have received a copy?
yes, sir.
Okay. List this matter after 4 weeks. Okay. Then will be considered later.
My lord, in the IA as well.
In the IA also notice issue.
My
Hard list as well. So, issue notice. You have objection?
Yes, lordship.
Okay.
my lord. Deeply obliged.
This after 4 weeks. Okay. Yes.
May I please proceed?
Yes.
Proceed, this every application is in connection with ALO PSPS number 26 of 2025.
Just a minute, sir.
Under section 332 C 324(5) of BNS.
Item 8.
Yes, 8 and 9 laws. 8 and
AB.
9 are connected. Yes, Lord.
You are protected by interim order.
Yes, Lordship.
So what happened there?
My Lordship has granted interim protection on 21/5/2025.
Yes.
Thereafter, on 2 occasions, matter was listed, but CD could not produce by the IO because of that only. And in terms of that interim protection, interim order, Lordship, I have appeared on 3 occasions before the IO. My statement has been recorded, Lordship. And I'm complying,
Shown arrested also?
Yes, Lordship. Bail bond was also executed.
Executed.
Yes, my lord, they have cooperated with the investigation and their statement has been recorded. And now that your lordship, the police has
comment, on their comment, they objected the granting of the bail. But in my humble understanding, Your Lordship, his custody is not deemed required because the offense involved is PDPP. The offense where the offense is non-bailable, other sections are bailable.
Okay, others are bailable.
Yes,
Yes,
Lord.
Lord.
And the
Except
PDP,
for section 3 of PDPP Act.
Yes, Lord.
the punishment is up to 5 years, madam, not even 7 years.
Okay,
So, with the strict condition, my lord, that they should not influence the witnesses or hamper and tampering with the evidence and cooperate with the investigation,
hmm.
this bail may be made absolute, Your Lordship. We don't have.
Pardon, Mr. Taylor. Learned counsel for the applicant. Also had Mr. Diete, granted additional PP for the state and staff by an order dated 21/5/2025. The accused applicant was granted interim protection with certain conditions. Oh no, with the direction to direction to the accused applicant to cooperate and appear before the eye of the case within 3 weeks. In compliance of the above direction, the accused applicant appeared before the eye of the case on which date?
On first was on 23rd
On 23rd,
5/2025.
23/5/2025. On his such appearance, the police has arrested him and subsequently released on execution of a bail bond. And after recording his statement, Mr. Theate, while referring to additional PP, while referring to the case study, submits that after obtaining interim anticipatory bail, the accused applicant is cooperating and appearing before the eye of the case. Eye of the case, the eye of the case, and he has been arrested and thereafter released on bail on the strength of the interim anticipatory bail granted to him by this court on 21/5/2025. From the having heard and having heard the learned counsel for the parties and on perusal of the record, it appears that the accused is cooperating and appearing before the eye of the case. And in view of that, the further custodial remand appears no longer required. Accordingly, the prayer of the learned counsel for the applicant for making the interim anticipatory bail absolute is allowed. Accordingly, the interim anticipatory bail granted to the accused on 21/5/2025 is thereby made regular and made absolute with the same terms and conditions that the accused applicant shall continue to cooperate with the eye of the case and appear before him on as and when called for. Next, that we shall not hamper or tamper with the evidence of the case in any manner. Next, that the accused applicant shall not commit an offense similar to the offense of which he is accused of. That next, that the accused applicant shall not directly or indirectly make an inducement, any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such facts to the court or to any police officer, or whether his jurisdiction.
Your Lordship,
Not
jurisdiction
necessary.
party or not
Not-
necessary, Your Lordship. They are local.
With the above, this
Evident.
bail application stands, allow them dispose of. Okay. The next, same, similar order.
Different accused.
Only
Same-
different.
same
order. Lordship, one small correction. I have appeared on 25 and on 4th. So my bail, I was on arrested on 4th.
Okay. You appeared
On 2 occasions, 25, 5, and then 4, 6.
both same, on the same day.
For
No,
same
Lordship.
offense.
On 2 occasions, I appeared before the IR.
Okay,
And-
appeared
and I
before the
was-
eye of the case on
25,
25,
5, sorry, Lordship, 23, 5, 2025.
23, 5, 2025, and
And then 4, 6, 2025.
4, 6 to 2025. And on which date you were?
4, 6, Lord.
Okay, okay. He was arrested on 4, 6, 2025.
Yes, Lord.
Okay.
Obliged.
Yes, deeply obliged.
Both,
Both.
25 and
And
24,
4.
okay.
Yes. Deeply obliged.
8, 9, okay. Yes, yes. Yes.
Yes, my lord, this is criminal petition for quashing of WPS case number 1523.
Okay.
And my lord,
Whether copy?
yes, my lord, the leading counsel, Mr. Titapu, is on medical at the,
Okay. You want adjournment?
yes,
Okay, Mr.
Tabatopu.
Hmm?
Tabatopu. I'm
Tabatop, you are
Tempti Pahi.
T?
Pahi.
Your name is there in the?
No, ma'am.
Okay, T, Advocate, Mr. T, spelling? Right. Submits that the conducting counsel is, what happened to him?
My lord, because of his mother ailment,
Okay, the conduct has some personal difficulties today, therefore pray for adjournment.
Philip
The Rani counsel
Meghalaya
appearing on
this
behalf of the
morning.
respondent has no objection. They are allowed list this matter after, when? 2 weeks,
After
3 weeks.
vacation, after vacation.
Okay, 3 weeks. This is item 10. Okay. 11 adjourn. Yes, 12.
Your Lordship. In
Adjournment.
respect of respondent number 3 and 4, 2 and 3 is
Okay.
service is still awaited.
Okay. You are Mr.
T. Tukur.
Lani counsel for the petitioner. Give your name, huh? He is present. The office note dated 18/6/2025 reflect that the notice upon the respondent number 2 and 3 is still awaited. In view of the above, list this matter after 3 weeks. Okay, Ms. Tijini Lani, additional PP Lani, for the state is present.
Your Lordship, the interim is there.
The interim order passed earlier shall continue till the next date of listing. Okay.
Obliged.
May I Lordship?
Yes.
Lordship, I'm appearing behalf of T Time. He is out of station.
He is out of station.
Yes, Lordship.
What is this case about? Okay, who appeared for the respondent?
We have taken consent for,
Why you have taken consent?
because I'm taken for consent for leading counsel is out of station and I'm taking adjournment.
Okay, you are Mr.
B. Sibo.
Your name is there?
No,
Mr.
B. Sibo.
B. Sibo, give name, huh? Land Council appearing on behalf of Mr. T. Time, Land Council for the applicant with the consent of the learning council for the respondent. Prays for adjournment of the matter for 2 weeks. Prayer allowed. List this matter after
2 weeks.
2 weeks. Okay. Yes. Yes.
May I lordship?
Yes.
Lordship, in this matter, TCR was called.
Service inspector. So service not complete.
And no, service already taken. This trial court record was called.
Service also not complete.
Service has also not been completed and the TCR
Right,
is
TCR also not yet.
available. Your
Okay.
Lordship.
You are Miss
N Hondi.
Mr. N, sorry, Miss N Hondi, Learning Council for the petitioner is present. Petitioner and Miss P. Jeannie Learning additional PP for the state is present. The office note dated 18/6/2025 reflect that the service upon the respondent number 2 and 3 is still awaited. The TCR as called for has also not yet received. In view of the above, list is made after 3 weeks.
Interim is zero, lordship.
Stop there. The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged.
Lordship. 15.
Yes.
No, it's not your case. Not my case. Vikas Chandra, right? Say. I'm for respondent.
Respondent number 2, status is still awaited, but they are appearing. Status is still awaited, but they are appearing council.
Which one?
Respondent number 2.
Which one is to be taken?
Lordship, service upon respondent number 2 has been completed.
Yes,
As
that-
they are
Okay.
available today, Your Lordship.
Okay.
Your Lordship, if remember, there was a question of maintainability with regard to if there is a provision under the code 482 does not lie, Your Lordship. That was open for argument, Your Lordship. On the next day, Your
Yes.
On the next day.
Yes.
Yes.
Okay.
You are Mr.
L. Teni, Lijatindi.
L. Teni, Learning
Yes.
Council for the petition. Mr. L. Teni, Learning Council for the petition. Staff. So Miss T. G. Learned additional PP is also present.
I'm for respondent number 2, sir.
Okay, Miss J. Jong Lujo, Learning Council, would appear on behalf of the respondent number 2.
2, yes, your worship.
2. Have you received the copy? Copy of the petition. Have you received?
Not yet.
Okay, I'll submit.
Okay, Mr. Teni.
Yes.
Learning Council for the petitioner will furnish a copy of the petition to the Learning Council appearing on behalf of the respondent number 2 within 2 days.
Yes.
Okay, 2 days from today. Huh?
Lordship,
Staff, huh? List this matter
2 weeks.
after
2 weeks.
2 weeks.
Interim was there, Lordship.
The interim order passed earlier shall continue till the next date of listing. Okay.
Lordship may also make a reference to the order dated 9/5 for maintainability, Your Lordship.
Okay, it's list this matter after 2 weeks, huh? On which date? The maintainability,
You can choose a fixed date.
okay. List this matter after 2 weeks, huh? The question of maintainability of the petition is kept open.
Yes.
Okay.
Deeply obliged.
Deeply obliged.
Yes.
Yes, Your Worship, this is a joint petition.
Joint petition.
Yes, Your Worship. Last time, we have already, hearing was already happened on last date.
Hearing, okay.
Yes.
No, this is
Today is
second
the
day.
sixth date. Yes, Your Worship. The matter was for fixed.
My lord, we have received the case diary.
Okay.
Matter can be disposed of, my lord. It's a very serious offense, my lord.
Serious.
Pechi Jumsi Taba.
Srimati Pechi Jumsi
Taba.
Taba.
Yes, Lord.
Taba. Miss. Okay. You are for state.
Yes, ma'am.
Okay.
Appellant.
Okay. The prayer is considered and allowed. Let Miss Pechi Jumsi, her name, be included as respondent number 1 in RFA. Okay, stop with the above this I stands disposal. And in the main, in view of the presence, presence required, record vote, in view of the order passed today in IAC 156 AP 2025, Shri Miss So-and-so, same name, Sabah, is implemented as
Sole respondent.
sole respondent
Yes.
in place of
Let Tabara. Tabarajan.
Tabarajan since this is. Okay, sir. Stop, Ampera. The appellant shall file amended course title. Okay? By including,
By incorporating the name.
by
Just go
inserting
repeat
the name of Miss so-and-so as respondent, sole respondent. Stop. The registry shall prove the issue. Okay, list is matter after 3 weeks.
3 weeks.
Okay.
Deeply obliged.
Unlisted, okay. Anyone present? Who made a mention? Who made a mention this morning? Prakash Sharma. Wait for some time, huh? Wait for some time. If he is present, ask someone to call. We just need to dispose. Okay. What else? Call for this matter. Yes.
Your Lordship, this is a part heard matter, Your Lordship.
Part heard matter?
Yes, Your Lord.
Okay. What was this matter about? Tapta sir. What was this case about?
Your Lordship, if you remember, there was, the victim was, there was an allegation that victim was, when she was a very minor, 2 or 3 years old, she was, given to the accused, Your Lordship.
Okay.
There was a
Okay.
allegation.
Okay, allegation. But then today it will be difficult because tomorrow.
Even I think so, because
It will be
last
difficult.
time I had just started my submission, Your Lordship.
Mhm.
It will take, even me, I'll take time, Your Lordship, because there was also a dispute.
We can fix another date.
Your Lordship.
Yes, yes. So that was.
Okay.
Because the accused is in jail, so.
Mr.
MP Taja.
Kagataja, Land Council for the appellant. Appellant is present. Miss Srijini, Land additional now. PP is also present. Staff, huh? Due to paucity of time, the matter could not be heard. Staff, huh, Para? Then there is a notification
Yes, Your Lordship.
that if for more than 30 days, if it is kept as part hard, then automatically it is
It
released. So
becomes-
no point keeping it
No,
as
yes, yes.
part hard,
Yeah.
okay?
My learned friend has proposed the date of Monday, Your Lordship.
In
Can
that
put
case,
this
Your
on
Lordship-
Monday, recusing Lordship as the part may be recused and matter may be heard of.
In view of the above, the part, the release from part hard. Huh?
Yes.
Matter is released from part hard. Stop.
Your Lordship, in this case,
When do you want, you said?
yes, regarding the date, then kindly allow me to seek my, to consult my senior. Yes,
Okay.
So
Then after 3 weeks,
after consulting with the senior, we will give the date to the,
Hmm?
after consulting with the senior, we shall give the date to the bench assistant.
okay, you are agreeable to
Yes.
that?
Even the,
Agreeable to that, he will give the date after consulting his senior.
yes.
Agreeable, okay? So on the request of Mr. Land Council, Mr. Taja, Land Council for the petition, that this matter we fix on dash dash, huh? Hmm. Okay. On the request of Mr. Taja, not being objected to by the council for the respondents, huh? Let this matter be listed on dash dash. Okay. Yes.
Yes, madam.
This is
My lord, I'm for a with prisoner, madam.
withdraw.
Yes, madam. Withdraw,
Okay.
madam.
You want to withdraw?
Yes, madam. Withdraw with liberty to
Okay, Mr.
file a press, madam.
You are Mr.
Jairam, madam. Jungir Ram. My name is
Jungir Ram.
Ritik, madam. Yes.
Jumgir Ramlani counsel for the petitioner. Comes that he has an instruction to withdraw this petition with liberty to file a fresh stuff.
Yes.
Okay. This criminal petition is dismissed on withdrawal with liberty as before. Okay, so are present, okay? Mr. General Council, additional PP is also present, huh?
Deeply.
Okay, much of. Okay, no? तुम्हारी ये इसको दे दो, हाँ?